Subject of today's talk is Proposition 19, which was passed this November in California with 51% of the votes. As Wikipedia notes, the proposition increases the property tax burden on owners of inherited property in favor of providing expanded property tax benefits to homeowners 55 and older, disabled homeowners, and victims of wildfires and natural disasters. According to the California legislative analyst, Proposition 19 is a large net tax increase of hundreds of millions of dollars per year. Brother Anastasios G. Konstantin Esquire is a member of the Oakland chapter. He is a first-generation Greek American. He graduated with honors from California State University, Hayward, with a Bachelor of Science, majoring in finance and minoring in economics in 1991. He received a Juris Doctorate from Golden Gate University in 1997. He has been working as an attorney at the Konstantin Law Firm since 1998. His vast experience across multi-legal arenas has led to a unique perspective and ability that he has brought him success in finding efficient and practical solutions to almost every single case he has ever touched. Mr. Konstantin is now primarily focused in the field of estate planning. In addition to his dedicated professional career, Mr. Konstantin is currently serving as the Parish Council President of the Ascension Greek Orthodox Cathedral in Oakland. Right now, everybody should be muted. Our presenter will be presenting his slide deck. If anybody has any questions, please free to use the chat box where you will write the questions, and at the end of the lecture, I will read them to Brother Konstantin. So here we go. You can begin.
Well, Dr. Kokinidis, I really appreciate that introduction. And I want to thank all of you for being here this Saturday afternoon to listen to this information about a new amendment on the California Constitution that I'm very passionate about, and not for good reasons, may I say. We'll just get into the heart of matter in just a few minutes. But first, I have to do this. It's just a quick disclosure. Let me get this out of the way. Watching this presentation does not legally bind the Konstantin Law Firm to you, the viewer, to a contract of any form. Nothing in this presentation shall be construed as legal advice. And again, I want to thank you for joining this conference and to get some clarity about what Proposition 19 is and what impact it may have on your families. It's great to see familiar faces out there. I am familiar with many of you, but a brief background, as you already heard, I am a past chapter president of the Oakland Chapter 171, past district governor. I'm also a past Supreme Counselor of the Order of AHEPA, and I also served as the Sons of Pericles Supreme President in 1994. It's amazing how fast time flies. Professionally, I am often referred to as AG, and I am the principal of the Konstantin Law Firm and have been an attorney since 1998. After more than 20 years of primarily working as a trial litigation attorney, and in many instances witnessing firsthand and litigated cases where families became enemies directly relating to a lack of planning and preparing, seeing up close and personal the financial and emotional devastation caused to people, my law firm now is exclusively focused in matters of estate planning and helping families protect their lifetime creation of wealth. As we get started, I want to remind you the disclaimer that what you just saw here, that this presentation is for informational purposes only. Though all of you may be similarly situated and have common concerns, proper and effective legal advice is unique to each of you as many factors are taken into consideration, such as your marital status, your age, the size of your estate, the assessed values of your properties, the competency and trustworthiness of your children, among many other factors. So now, I want to talk to you about what I, in my humble opinion, feel is truly the most clever, deceptive, and biggest sucker punch in California political ballot history since the passage of the proposition in 1984 that brought us the California State Lottery. Do you remember that one? It was supposed to raise all this money and save our schools. But I digress. Let's get back to the point of this presentation. Since the passage of Proposition 19 on the November 2020 ballot, I have literally spoken to hundreds of clients and colleagues about what this new law means and what to expect from it and what, if anything, can you do about it now? To the last part, and let's just pretend this is after February 15th, which is just, what, about 9 days away from now, that answer would be very simple. It's too late to do anything, except maybe hope that a new law would amend Proposition 19 or a successful lawsuit to declare some or all of it illegal. After such extensive conversations with so many people, I became convinced that most people did not have a clear idea of what they voted on when it came to Proposition 19. I believe today that I can explain this new law in a way that will make sense to you. To help you get the most out of this presentation on what Proposition 19 is and what impact it will have on your family, I have found it much more effective to delve back into a brief history and help you either understand or refresh your recollection on current laws as they are right now. In other words, before this new law goes into effect, I want you to have a good picture of what it is right now as you're sitting here listening to me. Because you see, if you don't have a clear understanding of what the current laws are right now before the change, then adding more information about the new Proposition 19 will only confuse you further. So let's take a look back. In 1978, Californians passed Proposition 13, which did many beneficial things. For the purposes of this presentation, the most important thing it did is it kept our property taxes on both residential and commercial from increasing more than 2% annually. Without Proposition 13, our property taxes would have reassessed annually based on fair market value. As you all know, the fair market value of California real estate has far exceeded 2% annually. I want to pause here and emphasize this distinction between your assessed value for purposes of property taxes and fair market value. This distinction will be especially important later when I talk to you about picking your poison. Your assessed value for purposes of your property taxes is the price you paid for your home or other property, plus up to 2% annually since that purchase. Side note here, and I will keep these to a minimum. There are other factors such as construction and depreciation on income property that also may affect your tax base. But that is beyond the scope of this presentation, and you do not need to know this or keep it in mind to understand Proposition 19. I want you to understand the basics so that you can be prepared to ask your trusted professionals the more difficult questions later. Many of you have asked me, so did Proposition 19 repeal or amend the 1978 Proposition 13? The answer is simple, no, not at all. Proposition 13 remains well and vibrant, if I can use that simplistic term. In fact, another proposition, number 15, was on the same November ballot as Proposition 19, and that proposition sought to effectively repeal the commercial property component of Proposition 13. Most people seem to know that, and that's not surprising given that the Howard Jarvis Taxpayer Association spent money to defeat it. And guess what? Californians, being aware of the attack to Proposition 13, voted against it. But I digress once again. The presentation today is about Proposition 19. So let's recap now. 1978 Proposition 13 is still good law. Your assessed value for purposes of your property taxes is the price you paid to make the purchase of your home or other property plus up to 2% annually since then. Now, let us peek at Propositions 58 and what I refer to as its companion, Proposition 193. We will discuss them together in this presentation as they are effectively one and the same. And I'll explain that in just a few moments. As I now turn my attention to cover the law on Proposition 58, please keep in mind that when I talk about your property, in addition to your personal residence, I am also including any vacation home or rental property. In 1986, Californians passed Proposition 58. Please make a note here that Proposition 58 is your child's best friend. Let me explain. Most relevant, this law created the parent-to-child exclusion with an unlimited dollar value for your principal residence and up to $1 million exclusion in assessed value for any other property. I want to add here that the companion Proposition 193 was passed in 1996 and expanded your child's best friend, Proposition 58, to include the grandparent to grandchild exclusion where the parents predeceased the grandparents. So from here on, I will simply talk about Proposition 58, but know that when I do, I am also including Proposition 193. Let me state this similarly to make sure we understand it, because this is the current law, and later I am going to tell you that you have a short window in which to transfer your property or properties now and put your children in your place. So currently, and once again currently means up until February 15, 2021, you may transfer now your primary residence of any value, $500,000, $5 million, $25 million, it does not matter because there is no limit, to your children without triggering a reassessment of the property tax base. In other words, preserving your Prop 13 basis. And in addition to your primary residence, you may transfer up to $1 million in assessed value per parent. The assessed value for other property should not be confused with fair market value. The easiest way to determine your assessed value is to look at your property tax bill. Usually in the lower right-hand section, you will find the words that read valuation information. For purposes of Proposition 58, vacation and rental property is treated the same. Children inheriting any of these types of properties are exempted up to $1 million per parent. If the assessed value of your rental property and or vacation home or the sum of the base values on all of your other properties is less than $1 million, your child can inherit these properties and your current property tax rates without reassessment. Any amount above $1 million per parent, of course, will be reassessed at fair market value. Take a look at this example. Let's say you own a vacation home, a rental property, a duplex, and an apartment with 4 units. When you purchased the properties many years ago, they were assessed at the following values. Vacation home, $100,000, your rental property at $150,000, which could be a second home, for example. Your duplex at $250,000, and that 4-unit apartment building at $400,000. Under the current law, all of these properties can be transferred and your child's property tax bill will remain the same because it is less than $1 million. Okay, so far we have only discussed the current law. Now let us move on to what life will look like after February 15, 2021. Proposition 19, here it is. This is what you read on your ballot. The Home Protection for Seniors, Severely Disabled, Families and Victims of Wildfire or Natural Disaster Act. Seriously, come on people. How could you have possibly voted against this? Don't you care about seniors and severely disabled persons? Surely you must care about families and victims of wildfire or natural disasters, right? So why are we even talking about this? Why have I literally talked to hundreds of you in the past 75 to 85 days and then came here this afternoon to talk to all of you now in person? Or I should say in person through this teleconference. Let us now answer this question. Californians narrowly passed Proposition 19 on November 3, 2020. Approximately $50 million was put into the campaign to get it to pass, and almost no money went to oppose it. Originally, this started off as an initiative measure that qualified for the ballot measure by the Association of Realtors. To be clear, there are benefits to Proposition 19 favoring older adults and disabled homeowners as well as victims of fire or other natural disaster. Namely, it allows the eligible homeowner to transfer their current home's property tax assessment base anywhere within the state to a replacement home. This means that if you have a low property tax base in your current home, you can sell and move to another home without a tax reassessment on your property taxes. This can be done up to 3 times and even allows tax assessments to be transferred to a more expensive home with an upward adjustment. This is great news to the current homeowner, you. Not so great news to your children, however. Let me explain further. After February 15, 2021, the property tax basis of your properties, and I mean all of your properties, primary residence and all other properties, will be reassessed to fair market value upon your death or transfer, with what I call one minor exception, which I'll get to in a moment. So what does all this mean in a nutshell? Well, it means if you are the current property owner and don't care what happens after you and to your significant other, if you have one, depart this world, things are great for you. In fact, you will be better off after February 15th than before February 15th. That's it. We're done. No need to listen anymore if that's how you stand. Go out there and make the best of it. If, however, you care about what happens to your kids when they inherit your properties, then you may want to continue listening here. Do you remember Prop 58 that I just talked about? I told you to make a note of that because it was your kid's best friend. Remember your home that you purchased for what seems like a cup of coffee back when? This, or should I pretend we are past February 15th and say, was the home that you could have transferred or bequeathed to your children without triggering a property tax reassessment? You see, to really understand the negative implications to your children that arise from Prop 19, then you must put yourself in their shoes. Let's talk more specifically about that. Proposition 19 effectively wiped out Prop 58, your child's best friend. How so? Because, and I'll repeat what I said moments ago, after February 15, when you either transfer or bequeath your properties upon your death, taxes will be reassessed to fair market value on that date of transfer or date of death. This includes all property, including your primary residence. Okay, I will now cover what I call the one minor exception. Your child can keep your low property tax base of your primary residence if, and only if, the child moves into that primary residence within 12 months of your death and the excludable amount is only $1 million of the fair market value. Anything more will be adjusted upward based on a formula to account for the overage. Let's briefly look at the formula through your child's perspective. When your child inherits your primary residence, if the fair market price at the time is less than your assessed property value plus $1 million, then there is no property tax increase. If, on the other hand, the fair market price of your residence is higher than your assessed value plus $1 million at the time of your death, then the property taxes increase to your child. What this means, in short order, is that unless your child can afford the higher property tax bill, that child may be forced to sell your primary residence, even though they would have preferred to keep it. Keep in mind, of course, that if your child does not move into your primary residence, this formula is moot, as the property taxes will reassess to fair market value regardless. Remember also that your child's best friend, Prop 58, is gone. Had 58 been alive and vibrant, your child would have inherited your home along with your low property tax base, regardless if he or she moved in. So now let's summarize Proposition 19. For you, the current owner, it's a time to celebrate. You can now sell and move, sell again and move, and finally sell one more time and move, all the while taking your favorable low property tax base with you. Before you celebrate too much, what about your children? Except for the $1 million primary residence exclusion, all of your property's property taxes will reassess to fair market value when you pass away. Is this really what Californians wanted? I'm not convinced. So what now? Fortunately or unfortunately, your options are limited. First, you can simply do nothing and hope that Proposition 19 will ultimately be repealed or amended by a future law or possibly get wiped out by a lawsuit. The vast majority of people that I talk to are in fact doing just this, nothing. And I will get back to this option in just a moment. Another option is to transfer your primary residence of any value plus up to $1 million in assessed value per parent to your kids before February 15, 2021. Of course, this can be risky, as kids can and often do make poor decisions. Some estate planning attorneys are recommending transferring your property to an irrevocable trust. Transferring your home to an irrevocable trust rather than leaving it in your individual name or the name of your revocable trust means that your home cannot change ownership upon your death, and the current assessed value of your home could possibly be preserved. Is this right for you? As I stated in the beginning of this presentation, to make such a decision, many other factors need to be considered. My firm has made the decision to not prepare any of these instruments after many discussions with other colleagues. However, that does not mean it may not be a good idea for you. Consult your trusted professionals to see what's right for you. I want to circle back to the do-nothing strategy. If I am effectively communicating this material, you may be wondering why the vast majority of people that I know are doing absolutely nothing. Here is where the final piece of the puzzle fits in, and if you grasp this, the light bulb will turn on in your head and you will be able to explain to others what the confusion is about Proposition 19. I call it picking your poison. And remember, to really understand this, here you put yourself back into the shoes of your child. The good. If your child receives your property now, your child steps into your shoes and enjoys your low property taxes forever. Your child does not need to move into the family home. Instead, he or she can rent it out. This could be especially beneficial to income property like an apartment building. The bad. And here comes that light bulb I talked about. I have been stating all along that your child steps into your shoes. Well, that also means that if your child decides in the future to sell your residence or any other property that you transfer now, that child will incur a capital gain just the same way you would if you were alive and decided to sell. And these gains can especially be large when dealing with California property purchased decades ago and can easily put the seller, your child, into the top income tax bracket for the year in which they sold. At the 40% tax bracket, for example, this could mean $400,000 in taxes for every $1 million in gain. Ouch! In contrast, if you do nothing and your child inherits your properties after you die, that child will receive what is called a step-up in basis. What this means in short order is that if your child were to sell that property or properties the next day, he or she would have zero capital gains. So now you're probably thinking, well, of course, it is better to let my child or children inherit my residence and other properties. And the answer so far with most people is yes, that's true. It is better to do nothing and let your children inherit rather than transferring now. Unless you have a property, and especially if it is your primary residence or a family vacation home that's been in your family for generations, and there is a beyond great likelihood that your child will hold on to that property or properties indefinitely, then capital gains are immaterial as selling isn't going to happen, and without a sale, there is no capital gain, and hence no income taxes due. In conclusion, you, in the shoes of your child, must pick your poison. How certain are you that you want to hang on to the property or properties forever? If you do, then perhaps a transfer now and lower property taxes is right for you. If selling in the future is a possibility, then taking the lower property taxes now will likely never offset any capital gains later should you decide to sell. Therefore, I call it picking your poison. I do want to thank you for listening to this presentation. I hope that you found it informative. And with that, I will take any questions, and I don't know if our moderator is putting those up in the chat box. You want to read them to me, or how do you want to do that?
I will read them to you. So, brother, silence our speakers because of the echo problem. Okay, so there is a question from Jack Molodanos. What are the pros and cons to transfer agricultural property parenthesis ranch, which is currently under the Williamson Act 10-year contract? Assume that the property will remain agricultural.
Yeah. Well, hang on a second here. That's a good question. I'm not hearing all of it. I believe the question dealt with agricultural property.
Mm-hmm. The Williamson Act, agricultural property.
That's a great question. Whoever is asking that question, if you could just give them my my law firm, my web address. Do you have that? Okay, I will put it in the chat box. I am happy to try and answer that question. It's a little bit beyond this presentation. I was just in another webinar with the assessor from San Mateo County that addressed this, and I have a little bit more information to pass along as it deals with agricultural property, because they did try to keep the rules a little bit different or try to include more law into it.
Okay.
How can I drop this in the chat box here so you can get this information? Yes. And I'm happy to email that information to that individual as well.
I will put it in the chat. I'll put it.
I think I can do it right now.
Okay.
Or I'll just put my email address. They can also email me that.
Yeah. We don't have any other written questions. Does any of the participants want to ask any question orally?
And Dr. Konstantin, I also have a few. As part of another presentation that I did, because I recorded this, I actually took a lot of the questions, the common questions that I received during a lot of my interviews with people. I can also happy to share those with you as well.
We had another question. George Buras is asking, what is the inherited property if it's a triplex? Can you move into one of the units as your primary residence? Is the overall property tax base then prorated?
Okay, so let's be careful on how we proceed on this one. So there's a difference between passing it on now versus after this law goes into effect. So I'm going to assume right now that this question is asking after. Is that correct? Is that
yes?
Can you
yes,
clarify?
That's correct. After.
Okay, if you transfer it after, and that child, you're saying if you transfer it to a child and your child moves into that residence.
No, my question was, sorry, let me just ask the question live. If the parent passes on after the 15th and
yes.
the property is inherited, and the property is a triplex, and the parent lives in one of the units, can you then move into that one unit as your primary residence? And what happens to the property tax for the triplex as a whole?
That's another good question. So on that one there, by the way, I should have mentioned it from the beginning, there is still a ton of unanswered questions about Proposition 19. This would be one of those nuances, but I think that some of the information is starting to come out on this, right? So this is still unsettled law, but the answer is that would qualify. In other words, that child can move into that one unit and claim a Prop 19 exemption. And the question that remains is, as to all of it or only 1/3 of it? That still remains unsettled law. But we know that that child will at least be able to preserve at least that portion that child occupies as the primary residence.
We have a question from Alex Solis, if he could ask it.
I'm unmuted. You can hear me okay?
It is easier if I can read it. For some reason, I'm not getting the question very clearly when it's coming orally, but if I could read it, it's a little easier for me.
Can you hear me okay?
Yes, I can.
My question is, I understand right now if your total value of all your family estate is a certain dollar amount, like under or over $4 million or something like that, or $5 million, that if it's being proposed to be and moved down, how will Prop 19 possibly affect that? You know what I understand the question?
No, and what would be helpful is, are we talking about income taxes here, or are you talking about property taxes here? Are you talking about how that affects you? Are you talking about the lifetime exclusion that you have to be able to bequeath or gift? I'm not understanding where your question is. When do you propose on making a transfer?
I was told your total family value is under a certain amount of money, you're taxed a certain way, and I heard that there's a chance it might be lowered down to like 1.75 million versus being a total value of 4 million or thereabouts.
Okay, so I'm hearing a couple of things in there, and I will just state it this way. If what you're talking about is one's lifetime exclusion from federal and state gift taxes, that amount currently in 2021 is 11.7 million. And that's
the number, yes,
per person. That is set to what we call sunset in the year 2025, where it'll back down to $5 million. That, by the way, just for those of you who may be confused right now, we're not talking about Proposition 19 at all right now. We're only talking about one's exemption, lifetime exemption from federal and state gift taxes. So that is set to go back down in 2025 to $5 million. Now, if on the other hand, what you're referring to is the per person amount that you can give now before Proposition 19 goes into effect, you can give now, just like we're talking about your primary residence. If you guys want to not focus on your primary residence right now, but other properties, you may have bought, let's say, a $20 million, a 20-unit building, for example, decades ago. And if the assessed value on your property taxes, in other words, if that value is $1 million, or let's say $2 million for a married couple, you can give that property now before the deadline to your children, and that property will remain with that property tax basis. Okay, if that's clear. Again, the danger, as I said earlier, is that if the child were to then sell that property at any time later, that's going to incur a tremendous capital gain. And that, when we say capital gain, we're talking about income taxes. I hope that I answered your question. If not, maybe I gave you more information that you can maybe clarify your question.
No, it was very, very good. Thank you very much. Can I ask a follow-up question?
Absolutely.
Real quick, do you think it would be, let's say, legality-wise, down the road, a year, 2 years, 3 years down the road, another proposition comes in to undo Prop 19, would it be advantageous to take your property and upgrade to a better property and move your property tax over in the event you're kind of like gambling, thinking that maybe, hey, you can take your house for $1 million and buy a $2 million house, carry your property tax over, pay a little extra, difference in the income or whatever, and then take the chance that 19 will change?
Yeah, and I believe that's Alex, if I'm not mistaken. I think I see Alex is the one who's talking now. Alex, that's a great question. And the reason I enjoy that question so much is that's the whole reason I'm sitting here talking to you guys right now. The goal that I have is to educate as many people about this as possible. That's exactly my goal here. I'm not, no other reason here. I really firmly believe that what you saw on that ballot, people were not aware of what they were voting on. Everyone was thinking about Trump and Biden and everything else going on in this crazy world that we're in right now. And Californians had no idea. That's why I refer to it as a sucker punch. So do I believe that it's going to be changed? In my mind, I have no doubt. I am confident it's going to change. I'm going to do my part, not only put my money behind it, but I'm spreading the word. I'm here volunteering time, educating as many people as possible. There's going to be a lot of people just like me doing this exact thing right now. So will it change? I believe so. I believe that if Californians knew what they were voting for, they would not have voted for this thing. It narrowly passed. And that's because of the deception. So again, I think an educated California citizens going to a ballot are going to either amend this or repeal it. I believe somehow, some way, the parent-child will have to come back in some form. What I refer to as your child's best friend, the 58. I mentioned it just moments ago that I was on another webinar just yesterday, and it involved the San Mateo assessor, and it was a real, and there was also a member of the Board of Equalization on there. And I can tell you that the sentiment across the room, and there was, I believe, 1,800 people that attended this webinar yesterday. And by the way, I keep saying yesterday, I'm actually now thinking it was on Thursday, but either way, it doesn't matter. But the sentiment in that room, and if you read the chat and everything that everyone was talking about, including the assessor, including the member of the Board of Equalization, they all believe that Proposition 19 is not, I'm trying to be politically correct on how I word this. They don't like Proposition 19. They also believe that it should change, but they have also no choice but to implement the law and to see it through. So they have to do what they're assigned to do.
We have another question from Jack Molodanov. Can't kids avoid the capital gains tax, the bad as you mentioned, if they get property before February 15 by doing a 1031 tax exchange?
No, no, they cannot. If they get the property now, well, yes and no. Let's answer it this way. They can absolutely avoid the capital gain if they keep that property either their entire lives and then they bequeath it to their kids. Okay, then there'll be no capital gains because there's no sale there. It'll just be a reassessment when they die to fair market value. That's what will happen in that instance. And doing a 1031 is immaterial here. That's just going from one property to another property. We're ultimately just talking about transferring your property. So they will not pay capital gains if they hold it their entire lives. Now, if they sell it, then yes, because remember, if you do it before February the 15th, they're going to step into your shoes. So what you really want to ask yourself is, would you have a capital gains tax if you're alive and you sell? If the answer to that is yes, then the same answer applies to your children.
I'm not seeing any other questions. Does anyone have a question?
So would you like me to share a couple of the questions that I received when I was talking to other people, and then let people here get a chance to maybe think of other questions?
Go ahead.
Okay. So let me. Am I still sharing my screen, by the way?
Yes.
I am sharing. Okay, I'm not aware. Okay, thank you for letting me know. All right. Here's one of the questions that I get here. Far and away, the most common question that I received is, does it matter if we have our properties in a living trust? Okay, I mean, that question I can't even tell you how many people said, oh, but I think we're okay. We have our properties in a living trust, and we set that up a long time ago, whatever. And let me give you my answer. No, it makes zero difference if you have your properties in a living trust, because the vast majority of living trusts are revocable. Those are the most typical ones that you use in estate planning. So that answer could, by the way, be a yes, as I mentioned in my presentation, if it were an irrevocable trust and it was specifically set up for Prop 19 planning. So that's that question. And then another question that I got is, let's see, this question was, does it make a difference in your analysis when one spouse recently passed away while holding community property in a revocable living trust? Now, this is a great question. So if you really understand Proposition 19 now, I want to add something else to it. This would be a perfect example where, this is just that one more factor that all of a sudden changes the entire analysis and shifts the opinion to, yes, it makes a lot of sense to transfer now. And the reason why transferring now becomes more attractive is because your child gets both the low property tax basis and a step-up basis for purposes of income tax. So remember, the child steps into your shoes, and if a spouse recently passed away, the surviving spouse received a step-up basis and hence can now transfer to that child before the deadline. Does that make sense? Another question that I get is, if my children are young, should I consider transferring property to them now? And that answer is, you know, almost across the board, probably not. There's way too many risks. You still do not know if you're going to have responsible children when they grow up. And even if they are responsible, you know, will they have creditors? What kind of marriages will they be in? So broadly speaking, no, I would not recommend transferring now. The bottom line is, unless you have mature and trustworthy children, I would not recommend transferring now at all. Another question is, if I transfer my primary residence before February 15, will my child be able to evict me before I die? That's another great question. People say to me, you know, when they want to get rid of that house, they say, you know, I do want my children to have that favorable property tax base. And to that I have to say, well, yes and no. If you simply transfer and do nothing else, like have an occupancy agreement, then yes, you actually could be evicted because you don't own the house anymore, they do. So these are some more of the detailed questions that you got to, you know, you have to discuss this with your trusted professionals before any of these decisions are made. Again, you know, we want to keep this presentation limited, and so we can't go into the granular details, but these are the types of questions that are, you know, what I call the next step analysis. That was another common question. It's not going to pertain here. That was just, do I only give advice on real estate transfers? No, of course we do all estate planning. But anyway, I will, let me minimize my screen here. Those were the most common questions that I received. And let me do this, stop sharing my screen. I'll stop sharing at this point. And I don't know if there's any other questions. If there are, I'm happy to take them. I think I see a hand up. Moderator, Dr. Kokkinidis, do you see a hand up there? I think it's Alex Souls.
I'm not seeing a hand up visibly, but
question. I'm sorry.
If you wish to ask one.
Dr. Kokkinidis, I'm sorry, I'm not hearing another question. Was there a question on the floor?
Yeah. Is there a question on the floor? Alex only said that he's good. Alex only said that he's good. So we don't seem to have any other questions right now. In that case, I wish to thank our presenter, and I see you in a couple of hours in the next lecture.
All right, Dr. Kokkinidis, everybody out there, please spread the word. Thank you very much for coming out here, and I hope to see you all soon one day.
Thank you very much.
Thank you, Taso.
You're welcome.
Thank you.